Hi, this is Drew Tignanelli. We're doing elder care planning, preparation, and implementation of seeking government assistance. I'm here with Alex Zarzecki of the law firm FRANKE and SCHERR. Alex, how are you?
I'm doing great today, Drew. How are you?
And so you're an elder care attorney. What's an elder care attorney do?
So, an elder care attorney is essentially an estates and trust attorney with a specialization towards some of the elderly population. And so we do things like Medicaid planning, and then your basic estate planning documents. So, wills, trusts, powers of attorneys. And then we also do some fun things like guardianships and special needs planning, which is a little bit more nuanced.
Okay, but we're going to be talking today about getting Medicaid to help us if we have a spouse or a parent that's headed into long-term care facility, and it could cost a lot of money. And let's go down to the risk. The risk is very significant because it could easily cost $100,000 to $200,000, anywhere in between. It could be as many as 1 in 2 Americans could go into a long-term care facility, and it could be as many as 3 years, 4 years, 5 years, 10 years that you could be putting at 100, 150,000. Now, long-term care insurance agents will use those numbers to try to scare you. We're not looking to use those numbers to try to scare anyone. We just want people to realize it's a significant risk, and you need to have thoughtful planning around this. And so that's why we're bringing this up. But Alex, one of the biggest misnomers is people think that if you go on Medicaid, that you're going to get poor care. I don't find that to be true.
No, it's not true at all. And so we'll use Medicaid and medical assistance interchangeably. They both apply to the same long-term care services that are applied towards an individual who's receiving some form of elevated nursing care in a nursing home. And at these facilities, the nurses don't know whether or not you're actually on Medicaid or if you're a private pay individual. You don't have like a red letter on your arm that says I'm a Medicaid recipient that gives you less care. You're going to receive the same quality care as everybody else.
In Maryland, though, you have to be in a 2-person room. You can't be in a private room.
No, unfortunately not. Maryland does not offer.
But they don't put you in a gymnasium either, right?
No, you'll usually have you'll have a roommate and.
Right.
Yeah.
But that's, but it's visitors. It's the amount of visitors you have come is really the determinant as to what kind of care you get.
Absolutely. So the more that your family can visit, the more that there is, I guess, a check on the level of care that you are being provided at that facility.
So the number one thing we have to tell our listeners is be proactive, be prepared. So what are some of these preparation things that they can be doing?
Sure. So we'll start with the power of attorney, which can refer both to a financial or a medical power of attorney. The financial power of attorney allows the principal, so you, to appoint another individual to act as your agent with respect to financial decisions. Now, that can be managing your bank account. It could be selling stocks, filing your taxes, selling your property. Essentially,
money.
Absolutely, gifting money. The agent steps into the shoes of the principal, and it's very important to have this document in place in case the principal has some sort of medical issue where they are no longer able to make decisions concerning their property. Usually something like a stroke, where you may not have the ability to communicate what you want to have happen with certain things or to manage your financial affairs. That's when the power of attorney will come into play. If you do not have a power of attorney in place, a lot of the times it will be necessary for a guardianship proceeding to be initiated to manage your assets.
You don't want to do that.
Really no, that's and neither do the courts. A guardianship is a last resort, but if you have a financial and medical power of attorney in place, you're more likely than not going to be able to avoid some form of a guardianship.
But you have to have a good financial power of attorney. And the Maryland statutory power of attorney, which is the typical one that a lawyer will pump out for you, isn't necessarily good.
That's absolutely correct. So Maryland does have a statutory form, and it's good for the most part, but it doesn't have every item listed that we, as an elder law attorney, would like. And there's actually legislation being proposed currently to amend the statutory form. It hasn't been.
That would be great. Yeah, if they do.
Yeah, it certainly would. And so there are two primary things that we like to add to our powers of attorney. The first one is a gifting power. The gifting power allows for gifts to be made, and that is one of the tools that I, as an elder law attorney, utilize for a Medicaid spend down. The second one that we recommend is that the power of attorney allow for the ability to create and fund a trust, and more specifically, a special needs trust. One of the ways to immediately become eligible for Medicaid and avoid the look back period is by placing assets into a special needs trust. Transfers to special needs trust are not subject to penalty. So having those two items in your power of attorney is very helpful and helps avoid having to have the court intervene if you're doing a Medicaid spend down.
So, Alex, I get a lot of people come to me and they talk to some elder care attorney and they're perfectly healthy. There's no problem yet. And they said to them, hey, I'm worried about this. And next thing you know, their assets are sitting in Medicaid trust and they're putting life estate deeds on their house. These things can be effective tools, but should they be used early, or are they best for when you're approaching a situation?
Well, the problem is you never know when you're actually going to need Medicaid. If we knew the actual date that you were going to require Medicaid, get sick, and need to go into a nursing facility, this would all be easy. It's the unknown. So I'm not sure that there's a correct answer to your question. It's very dependent on each person's situation, their financial affairs, and their family makeup, as to what tools are utilized to accomplish those goals and determine what's best for that person from a Medicaid planning perspective. Because you mentioned a Medicaid asset protection trust. A lot of people hear about these, but once I actually explain how restrictive these trusts are, most individuals are no longer interested in these trusts, just because essentially you lose the control to manage your assets. And if you're a relatively young, healthy individual, the last thing you want to do is pass off the ability to manage your assets to another individual. So it's very dependent on each individual as to how they want to do their planning.
So the other thing too is I call it the retirement community advice, So they're sitting in the dining room and somebody says to the other one, you need to put your brokerage accounts in joint name, and you need to put your bank accounts in joint name, and you need to put that house you still own over there in joint name, because that's going to save you if you ever have to go into, et cetera. There's what's the truth behind this?
Uh, like I said earlier, there's not necessarily a correct answer to everything or to your question, because each situation is specific. If we're talking about just a hypothetical husband and wife, yes, it makes sense for the most part for assets to be joint. Because
I'm talking about with children mainly.
You're talking about children. Okay, if we're talking about children, then no. So one of the major benefits to inheriting something upon another individual's death is something called a step up in cost basis. And if an asset is jointly owned with another individual, you potentially lose that step up in basis. And so if we're dealing with appreciable assets, putting someone else on title for something puts you at risk of having tax consequences that you weren't anticipating originally. Additionally, what your children are, by having your children on as a jointly titled person, that effectively opens their creditors to having the ability to collect on that asset if they have any issues. So you really need to be careful before adding kids onto any bank accounts, just because there may be implications that you are not expecting. What I tell clients is that hold off on adding them as a joint owner. Instead, have your kids utilize the power of attorney. The power of attorney will give them the same ability to manage those assets that being a joint account owner has.
In other words, don't take free advice. Make sure you have somebody that really knows what they're talking about. So let's go on. Let's go on to our next one. So Medicaid can be a very confusing term because you hear it thrown around a lot. Matter of fact, in the Obamacare health exchange, people can get on Medicaid, and there's no asset test. There's only an adjusted gross income test. But we're talking about a very different form of Medicaid.
Yeah, we're talking about medical assistance long-term care benefits. And so here it's primarily an asset test. In Maryland, your accountable resources should be less than $2,500, excluding your primary residence and your car. Beyond that, you can't really have any other assets. And so we're talking about bank accounts, brokerage accounts, retirement accounts, life insurance policies. Everything is included in that countable resource if it has a cash value. So it's a pretty big undertaking. And the big thing that people hear about Medicaid is the 5-year look back. And it's a real thing. It's essentially like it's an audit of the last 5 years prior to entering into a long-term care facility. And so when you engage a Medicaid attorney, anticipate that you are going to have to essentially provide all of your accounts over the 5 previous years in order to get that financial qualification for Medicaid. It's a pretty intense process.
No, you know, when somebody goes to Social Security and asks for help and get benefits, the Social Security representatives are very helpful to help them think about and how to get benefits and so forth and what would be the best for them. Medicaid representatives are very different. They will not guide you through the process.
They will not. And
they will actually discourage you that you don't even, they won't even tell you that you have legally can get benefits possibly.
No, and they won't tell you that there are ways to save some of your assets and qualify for Medicaid at the same time. And that's where we come into play. Depending on what your situation, whether you're a single individual or whether you're a married couple, there are different types of planning procedures that can help save the family money, but at the same time qualify the individual who requires care, get them on Medicaid. So it's really important to talk to an attorney who's familiar with the process and knows what they're doing. A Medicaid agent and the nursing home are not going to help you with that.
And like we said earlier, it's state by state. We're talking the specifics of Maryland. I live in Florida, and actually Florida has a much easier process to go through than Maryland does. It's not easy, but it's easier than Maryland. So that's just a little to do about different states make big differences. So Absolutely. Let's look at the married one. So a married couple actually has a lot of potential to get government assistance, and they just need to know this. And there's nothing wrong with getting government assistance. It's not immoral to ask for government assistance, even if you've got a reasonable amount of assets. I don't know that somebody with $10 million needs to be asking for it, but someone with a net worth of 700, 800,000, $1 million, they could still very easily get approved, correct?
Absolutely. We do this quite commonly. Like you said, maybe someone with $10 million is better equipped at privately paying through maybe long-term care insurance or other mechanisms, income-producing mechanisms. But definitely someone who's got $1 million that's tied up in real property, retirement accounts. There are many ways to effectively save assets and qualify the institutionalized spouse for Medicaid.
Right. And it's important to understand that you guys talk about the need-based spouse or the potential institutionalized spouse. And the community spouse would be the one that's healthy outside of the nursing home, right?
Correct. The one who's presumed to be living at the home.
Right. And there's two big things. They have to have a diagnosis that they need long-term care, and they
Correct.
need to have the asset. In Maryland, it's strictly an asset test, right? It's not an income and asset test.
Well, there's a slight income test. The income test is that if you have enough income to pay the cost of care, you're not going to qualify for.
Well, of course, but
yeah.
Who has 120,000 or 150 of pensions and Social Security? There are people that do have that,
Sure.
And it has to be just your pension and your Social Security, because if your spouse has that income, that doesn't count in the qualification, does it?
No, it does not.
So let's say I have a pension of $20,000 and my wife's got a pension of $150,000, and we've got 800,000 of assets. She could still get qualified for my Medicaid, couldn't she?
That is absolutely correct. And
but if it was the other way around and she had 150,000, she's the one with care needs, she may not be approved because her income's substantially higher.
Possibly.
Well, if she gets benefits, it's not going to be a lot because her pensions and Social Security are going to take care of it. So, but now this gets interesting because, if one spouse has a lot of income and the other one doesn't, the one that has a lot of income can continue to keep that if they're the healthy spouse, right?
That is correct, yes.
But if the institutionalized spouse has all the income and the other one has very little income, now it gets complicated because their income's going to go for their care, and you're only allowed to keep what?
Yeah, there's a calculation as to what you're entitled to receive. But primarily the institutionalized spouse, their income is applied towards the cost of care.
Yeah. So that becomes you always want the lower income spouse to need care, but we can't always plan that, right?
No, we can't, unfortunately.
So we've got this asset test. So what's the asset test? What if my wife were going in a long-term care facility and I was applying, what can I as a spouse keep?
So there is a maximum spousal share that's right around $137,000. So essentially what our goal as a Medicaid attorney is to have assets up to that amount protected, but we can actually protect more. And usually one of the ways that we do that is through a single premium annuity. So the assets over that community spousal share go into this annuity, which in turn becomes an income producing asset, which is not something that Medicaid can collect against. The actual avenue to getting towards there is really where our work comes into play. And it's just about converting assets that aren't protected into this annuity so that you're able to protect as many assets as possible without having to spend them down for Medicaid purposes.
But I can keep a house too, right? Up to what, 750,000?
It's about $600,000 in Maryland.
That's the equity
that's the maximum equity you're allowed to protect in Maryland.
Okay, so let's say I had a $650,000 house with a $250,000 mortgage. What would be one of the first things you're going to do? You're going to pay down that mortgage?
You're darn right. We're going to pay off. We're always trying to pay off debts and prepay for things that you're going to need in the future. So for something like a funeral burial policy, paying off debts is usually one of the best mechanisms for a spend down, getting rid of debt.
You're also allowed to keep a car too, right?
Yes, you're allowed to keep a car as well.
What if I want to keep a Tesla X car that costs $115,000?
You should be okay with that. Medicaid is not specific as to what type of car. So if you've got a Tesla X or a Ferrari in the driveway, I don't think Medicaid is going to be able to tell you that you need to sell it, unfortunately, for them.
But now one of the key problems become, now you pointed this out, and this is very important for our listeners to understand. If somebody's got, a family's got 800,000 of assets, and let's say one spouse has 40,000 of Social Security, the other one has 40, Okay, I'm allowed to keep my 40. This one's 40's got to go to the, so now I've got 800 of assets. Let's say 600, also in addition to the 800, I've got a house worth 600,000 with a $200,000 mortgage on. I'm taking 200 of my 800,000 assets and I'm paying that mortgage off. So now that 600 is protected in that house, right?
Absolutely.
I'm going to buy a brand new car. I'm going to trade my car and buy a brand new car, relatively expensive, that I can keep. Okay, now I get to keep that. Now let's say I've got 500,000 left. Okay, what you said earlier is key. You're going to take that 500,000 and you're going to create income with an annuity in the healthy spouse's name, because income in my name doesn't count against my spouse's Medicaid needs, right?
That's absolutely correct. And that's why doing Medicaid plans for couples is much easier, and you're able to save more than you are for an individual.
Right. But here comes the kicker, right, Alex, is that the annuity pays off in 3 years.
We sometimes do even 2.
Yeah. So in essence, this isn't an annuity that's going on for the rest of my life.
No.
This is an annuity that I'm getting all the money back from it in 2 to 3 years.
Correct.
And my spouse is still, so I reaccumulate all that money in 2 to 3 years. But the key is, what kind of money did I have to create the annuity with? So let's say my spouse has an IRA worth $300,000, all pre-tax money. Now I have to have that trade-off. Do I pay taxes on it and buy the annuity so that I protect from paying that long-term care bill that could last for a long time? Or do I sit back and assume that her health is so bad that maybe she's not going to live 2 or 3 years? And this is where it really gets difficult, because you have
Absolutely.
that emotional and financial intertwining going on there. It's ridiculous.
It is. And that's where you have to have realistic conversations with the families and figure out what their ultimate goals are, because not everybody's going to make the same decision. So it really comes down to determining what you're comfortable with and what the expectations of the family are. There's never a right answer, because anybody can go back and play Monday morning quarterback.
Right.
But making the decision in the moment, it's definitely very difficult. And so you definitely want to speak with somebody who is doing this on a regular basis and understands the implications of every decision that you're going to be considering.
Yeah, absolutely. But the point is that there's a lot you can do with a husband and wife when one of them is headed to a long-term care facility. There's a lot that can be done, and they're not going to diminish the care that they're getting. And it could save the family. That healthy spouse could live another 10 or 15 or 20 years. And if those assets get drained down, Alex, it's a disaster.
Absolutely. So, and if you're a married couple and your spouse gets sick, do not think that all is lost. There are ways to protect assets.
Yeah. Now let's go on to the single person. You said this very well. $2,500 is it, you know?
That's it. It's very low.
You can't have the Tesla in the driveway now.
No, I don't think you'll be able to pay the energy bill to recharge it.
That's true. But there's still a health test. You still have to prove that your health is so bad that you need a long-term care facility, right?
Absolutely. Like I said, you have to require assistance with 2 activities of daily living.
Right. And that can be difficult to actually get somebody to make that kind of assessment for certain people.
Yeah, and so sometimes if the department that's making the determination isn't agreeing with that assessment, sometimes you do have to hire private nurses to do an assessment and make that claim and potentially appeal it to the Bureau for the purposes of qualifying.
And so, with that single person, again, it gets down to the, what kind of income do they have? What kind of assets do they have? But how do you help a single person to protect some of those assets if they needed a long-term care facility? Is there a way to do that? Or would you have to do that stuff way in advance before they need the facility?
Well, ideally, yes, that you would have planned beforehand, but that's really hard because no one knows when they're going to need this care. So we mentioned earlier the ability to gift with respect to the power of attorney. So gifting is a pretty common method for a single applicant for Medicaid purposes. And what happens is if they are substantially over that asset test, and maybe they've got $200,000 in assets, what we will do is have them gift their asset to a family member to get them below that $2,500 mark. But there will be a penalty that is incurred. The state has a divisor by which they calculate how many months you're going to be penalized based off of the amount of the gift. And what we have people do is that the gift recipient will then pay privately for the penalty period based off whatever the amount that the gift was. And the usual outcome is that you're able to save right around about 1/2 of the gift using that method. So if we're talking about a $200,000 gift, you're usually able to save about $100,000. So it's much better than the alternative of spending down and applying everything directly to the nursing home.
Right.
So yeah, there are ways to save for a single individual. They're just not as many options as there are for a married applicant.
There is one potential thing, that is, what if one of your children is disabled?
Yes, absolutely. So if you have a disabled child, a
Now explain
transfer.
what disabled means in this context, because some people could be visualizing an incredibly disabled person, et cetera, et cetera.
So when I use the term disabled, I am using it from the Social Security definition. So you could be blind, or it's the inability to engage in substantial gainful activity for a period exceeding 1 year. So essentially what that means is that you don't have the ability to work and earn a living. That's what disabled is. And so if you have a child who is considered to meet that Social Security definition of disability, making a gift to that child or into a trust for the benefit of that child is not penalized for the purposes of a Medicaid application. And you could essentially become financially eligible immediately if your complete transfer is just to that disabled child or to that trust for the disabled child. It's definitely another option.
And when that situation is available, that is used frequently, isn't it?
Yes, sir. We use it quite frequently if it's available.
Yeah. One thing I didn't talk about when we were talking about married Alex is, let's say we go through the whole process and my spouse gets approved for Medicaid, okay? And whatever I had to do it, she gets approved for Medicaid. 6 months later, I have a lotto ticket and I find out that I won $150 million. How much of that 150 million do I need to use to pay for my wife's long-term care if I, instead of Medicaid?
Unless the Medicaid recipient was the one who bought that ticket, that's your money. You do with it as you please. Medicaid is only interested in what your assets were at the time of the application. So what happens afterwards, that's completely your business. Medicaid cannot make a claim for any assets that are earned or accrued after the date of application.
But it's amazing stuff, So let's go on to the next one here, because so we have that 5-year look back. We talked about that and the inability to tell. So what records is Medicaid going to say to you, Alex, and your client? We want this, what? What is it they're going to want?
They want complete bank records for the past 5 years. So your checking, your savings account, your brokerage, your retirement accounts, they want everything.
And how thorough are they going to be?
They're thorough. So when we do a Medicaid application, we have our paralegals and they go line by line. And essentially what they're looking for are activity that's out of the norm. So we don't care about your monthly mortgage payments or your Visa card that's being paid on a monthly basis. It's the things that are unusual, or they're little blips that are more than $1,000 that Medicaid is going to be like, oh, what's this? Essentially, what they're looking for is they're looking to see whether or not you did anything, if you made any gifts for the purposes of avoiding or for getting Medicaid eligibility. That's essentially what they are looking for.
So what do you do when you've got the child who has the power of attorney, okay, and mom's, slipping, okay, and that child is using mom's money and sucking up $80,000, $100,000? How does that impact a Medicaid application?
And you're indicating that it's not being used for the benefit of the mother?
Oh, no, it's clearly going to the child. They're just using mom's money. I see it all the time.
Yeah.
You probably see it all the time. Does that
Yeah,
cause?
that's going to pose a problem, unfortunately, for a Medicaid perspective, because they're going to ask where was all this money applied? And as to my earlier question, how was it used for mom? And if you can't provide sufficient documentation or verification that it was actually used for the benefit of mom, then Medicaid could potentially penalize you for those transfers. Yeah, it's definitely problematic. So it's very important if you mentioned the power of attorney. If you are serving as a power of attorney for someone, it's very important for you to keep all documentation related to the management of that person, because it might become necessary for you to produce that down the line, especially if you are going to eventually do a Medicaid application.
So let's say mom was going, her health was going down for 3 or 4 years, and I stay home and I take care of mom for 3 or 4 years, and it finally gets to the point that I can't do it anymore, and
Yep.
she's going to need a long-term care facility. Can I get any reimbursement for the time and effort that I put into that?
You definitely can, but the thing that I heard was that you provided care for more than 2 years, that mom didn't have to go to a nursing home. And what Maryland actually offers is if you can prove that you took care of a parent and didn't, when they would otherwise have required some sort of nursing care, you can then essentially be able to gift a house to that individual and qualify them for Medicaid immediately, because you provided care for 2 years when otherwise Medicaid would have been required to provide that care. So that's what I heard out of that hypothetical, but I don't think that was your question.
Well, I mean, that is sort of the question. So what if I'm single and I have a house, but I haven't sold it, but I have no money left? I don't have even 2,500 left. Can I still get approved?
You have no.
All I have is a house worth $300,000, and I have no other assets. Can I get approved for Medicaid?
Yes.
But I have a house worth $300,000, Alex. How do I get approved?
Well, a house is not a countable resource for Medicaid purposes. The problem that you're going to run into is how do you maintain the house after you get approved, because your cost of care is applied, your income is applied towards your cost of care at the facility. So yes, you'll be eligible, but unless someone else is able to pay for the expenses related to the maintenance of the house, you're not going to be able to.
Does Maryland put a lien on the house as they spend for Medicaid for me?
Unfortunately, yes. So if you are eligible for Medicaid and you own a house, they will place a lien.
This is only if you're single, though, right? It's only if you're
correct.
As married, it's excluded asset, right?
Correct, and yeah, and even if they're married, we get the title out of the spouse's name who's in the facility off the title of the property to avoid any issues down the line. But yes, it applies to a single individual, and Maryland could potentially place a lien on the property. And even if they fail to place a lien on the property, they'll file a claim against their estate. And when that person ultimately dies and the house is probated, they'll get paid that way. So Maryland gets paid back either way.
I heard about 20 years ago, an elder care attorney once say, but this was 20 years ago, who knows if it applies today. He said that if Maryland puts a lien against your house, okay, and all the years you're in the long-term care facility, and then let's say your end of life is two months off. You can tell it's clearly going downhill. You're in a hospice, and the family brings you back into your house, and you die inside that house in the last 2 months, that Maryland's lien would be removed. Any truth to that?
I'm not certain. I don't want to say no.
I mean, it was 20 years ago this guy said this. I always remembered it, but I've never had that situation where we were ever going to do something like that. So, but it's an interesting concept if it were true. Let's move on.
I'm actually going to do. I'm going to inquire a little bit further and see if that is something.
Yeah, we'll see. So Medicare does not pay for long-term care. Let's make sure everybody heard that. Medicare is for seniors 65 and older. Medicaid is for people with no assets and need government assistance to pay for long-term care. Medicare only pays limited amount of long-term care benefits.
Correct. So when you go into a hospital, and as your slide shows, you're there for 3 days, Medicare will pay for the first 20 days of your rehab. But beyond that, you have to privately pay the copay that's associated for the remaining 100 days of coverage, and then you're completely private pay.
Right, right. Now, what if they put you on hospice? What if your doctor says you're not going to live? Will Medicare pay for the hospice?
Medicare is supposed to provide the hospice care.
Yeah, but it really requires a doctor to say that your life
absolutely
is
and they're not going to make that determination lightly. I mean, you have to have a very short life expectancy to get that determination.
Right. So, with what we just went through a tiny little piece of everything that you do on a day-to-day basis.
Yes.
And I don't even think they can begin to grasp how thorough Medicaid is on that 5 years of every single piece of paper dealing with your finances for the last 5 years that they're going to go over, and everything they're going to do to try to deny you benefits. And we just touched a little bit of this and why you need somebody like yourself to do this. Do not try this on your own.
No. And really, like I mentioned, there are avenues to save money. And that's what our goal is with clients, is to maximize your savings and limit the amount that you actually have to pay towards the state. There are manageable rules that allow for this. We work within those rules and try to provide the best advice we can to our clients based off their individual circumstances.
Right. So I just want all of our listeners to keep in mind that the Financial Consulate is an independent, fee-only fiduciary firm, a member of NAFA. We cannot take referral fees. We don't take commissions. When we refer somebody, we do it only because we believe they will do the job that you need done. And that's it. We do not get anything from Alex or FRANKE and SCHERR. We don't want anything from them. We're strictly bringing Alex and this firm to light today because they have been extremely helpful with some of our clients who've had significant issues with either their parent or their spouse and helping them get approved for Medicaid. And we really appreciate all your firm's done for our clients.
Happy to do so, and we'll definitely continue to do so in the future.
Yeah, hopefully this is the right information for you, that I got it all spelled right and everything.
You added an extra E to the FRANKE. So FRANKE is actually FRANKE. And my email address is FRANKELDERLAW.com.
There you go. Well, I'm sorry. I just wanted to make sure you got that right so that everybody sees it right. But the phone number is good, right?
The phone number is good. That will continue to work well.
So it's Zarzecki at FrankeElderLaw.com. Candace SCHERR is the managing partner of the firm, I believe, right?
Yes, sir.
Yeah. And Jason Frank, who really found the firm, he's retired about, gosh, a good 6 years now.
2019.
Oh, well, it's only
not that long yet.
Oh, well,
it's felt like a while, but
a long
yes.
time. Well, I appreciate
a lot has happened
Alex.
since 2019.
You have anything else to add before we finish up?
No, but if you have any questions, feel free to call our office. We're happy to initially speak with you. And if we think that we can assist you, we'll obviously try to get you into the office for an initial consultation and go over what your options are. Please don't think that all hope is lost if you've got a sick family member. There are avenues and there are ways to save money and accomplish your goals at the same time.
All right. Well, Alex, I appreciate it. And that's the end of our elder care seminar. This is Drew Tignanelli saying God bless.